78, Anderson versus Anderson. Counsel?
May it please the court, Lyle Hoydu for Jack Anderson. All nuptial agreements are governed by DRL 236B3, and that's a statute that this Court of Appeals characterized as unambiguous in a prior case called Matisoff. In this case, 3 judges examined the agreement in dispute. They looked at the applicable statute, and they determined that it was valid because it complied with the statutory terms. In reaching that decision, the judges applied the plain meaning to the statute as this court did in the Matisoff case.
So, counsel, if I can interrupt you, I'm on the screen. Hi. So, in Matisoff, we left open the question of whether or not the acknowledgement had to be contemporaneous with the signature. Why don't you address why the majority of the appellate division is wrong to take that position?
Yes, Your Honor. Well, first of all, a contemporaneous acknowledgement is not required by the statute, so it's not one of the terms that is specifically outlined. 2 is there's no real no definition as to what is meant by contemporaneous. The certificate itself, there's a part where it says, quote, the party acknowledged that he or she signed, end quote. And that would be past tense. So it presumes that the individuals are signing and then can later present that for
Yes, that's true, but that only means it doesn't have to be simultaneous. That doesn't mean it has to be contemporaneous. It strikes me those are 2 different things. But let me try this a different way. How is one party to the agreement holding off on the acknowledgement 7 years until just before filing for divorce really in line with the purposes and in recognition of the purpose of the acknowledgement requirement, the other formalities, and in recognition of what, again, the court has said over and over is, you know, that moment that you realize the consequences of signing that prenup agreement. Strikes me your client is making that assessment years later in a different context from the other party, but I think we have said in the past that the point is that these parties are assessing this at the time that they are deciding whether or not to enter the agreement, and that's when they sign, and that's when those formalities ensure that the weightiness of these choices fall heavy on them and that they've thought them through.
Your Honor, we know that in general practice, these agreements are signed in counterparts. So whether that's, in my own practice, I can say that they are either days apart, weeks apart, sometimes months, and I've even had them years apart. But it doesn't create a problem because it's a question of how the parties executed it, and there's no challenge during that pendency. In this case, the wife accepted the benefits of the agreement during the course of the marriage. She never raised any issues. There's no claims of fraud or duress here. And she never sought to revoke or rescind.
So let me ask you this over here, sorry. If Mr. Anderson had never signed the agreement, would it have been enforceable against him?
Not under the code, no.
So then, if we don't have some sort of contemporaneous requirement, that doesn't mean instantaneous, it might be in a month or 2, but something, you're essentially converting an agreement that the parties thought was going to bind them both into a one-way option for the non-signer.
And that was the rationale, Your Honor, that was raised by the Fourth Department.
And so what's wrong with that?
I think there's 2 problems with it. Number 1 is in this particular case, if the husband enforces the agreement, the wife gets exactly what she expected. If the husband opts not to enforce the agreement, then presumably that favors the wife and she gets something more, which would be a windfall.
Well, I don't understand that because not necessarily. I mean, what if all of a sudden he became bankrupt?
And you lead me into the second problem, Your Honor, that's exactly what it is it creates a subjective standard. So now the judge becomes outcome-oriented, so instead of just objectively calling balls and strikes, the judge has to consider how that call is going to affect a particular party. So if,
Yeah, but it's not purely subjective. Of course, there have to be some boundaries. I get your point. I'm not going to disagree with you on that. But of course, it could have been resolved if your client had had it acknowledged within a reasonable period of time.
well,
Again, it doesn't, I do think there is a difference between contemporaneous and simultaneous. And the court below didn't say it had to be simultaneous or that they both had to do it at, before the same individual. So yes, of course, the circumstances might require that this is not done simultaneously.
the problem, Judge, is we're now going into an area of, as I indicated from my own practice, and I'm just in general practice, but I've got these agreements, as I said, days, weeks, months, and years apart, where the parties signed them. There
But is that a
no-
good thing, counsel? Here, sorry. You know, that may happen, but is that a policy we want to encourage? I mean, it may be in your practice people sign these years apart, but why would we want that?
Well, my concern, though, is a rule that retroactively invalidates all these agreements that we think are valid.
I thought you had earlier said that in your experience, they were almost always signed simultaneously.
No, I must have misspoke.
Okay, I must have misheard you.
The vast majority are done in counterparts. The vast majority.
In counterparts contemporaneously?
In counterparts, meaning that the...
No, I understand, yeah, but within the week of each other?
Your Honor, it's sometimes the same day, it's sometimes within weeks, it's sometimes within months.
No,
and
I got that part. I was trying to ask about frequency.
I think that within, if the general rule is that they sign in counterparts, the majority of them are closer to the days and weeks as opposed to months and years. But we have agreements that are out there, and there's never been a statutory prohibition is the problem. And if we say that DRL 236B is broken, and we want to fix it,
But what if we say you need to do this within a reasonable amount of time? Would we really be changing the law because of all these people that signed it within an unreasonable amount of time?
is that a 5-day rule? Is that a 5-week
But
rule?
that's
Is that
that's an issue the courts deal with all the time. What's a reasonable amount of time?
Well, again, Your Honor, the problem is that it leads to potentially different calls by different courts if we're going to use a reasonableness standard. And then it creates an uncertainty in the law. It undermines the general policy, which is favoring these folks coming together and making their own agreement.
Yes, but that was my point before, that the purpose is indeed for them to come together and appreciate the consequences of the provisions of the antenuptial agreement, to decide it for themselves and sign this and comply with all the formalities. It strikes me that they're not coming to an agreement if, with your example, years later, or this case, 7 years later, the husband decides, you know, I'm going to get to that courthouse first and get divorced, and let me get this thing acknowledged now that my lawyer has told me I got to do that to make sure this is effective. Do we want to have that kind of unilateral conduct that is not based on what the parties knew within the same amount of scope of time?
I
mean, what's wrong
understand-
with just saying it has to be reaffirmed?
I understand. I see that my time is up.
If you would like to finish your thought, counsel, go ahead.
Judge, I get it. I go back to the dilemma that court talked about, though, in Matisoff, which is Are you guided by the plain meaning of the actual terms of the statute, or are you going to insert exceptions and requirements in order to achieve some other goals? And the court previously found the statute was unambiguous. The statute, I would argue, hasn't changed, and I would simply ask the court to find in this case, for the very same reasons, that it's not ambiguous. It's not required to be simultaneous or contemporaneous. It can be done in counterparts, and that takes over a period of time. And if we want to come up with a new rule, rather than invalidating all these existing agreements, something that is prospective, that is at least in the future, that the attorneys know how to advise their counsel.
Thank you, counsel. Counsel?
Thank you very much. Your honors are obviously very well familiar with the facts of this case. The one undisputed fact of this matter is that on September 11th, 2011, the date that respondent signed and had acknowledged the agreement, there was a time period from then until May 31st, 2018, where there was no enforceable agreement.
Counsel, if I can interrupt you, counsel, I'm on the screen.
Yep, sorry.
Hi, no, that's fine.
Hello?
Why isn't your adversary correct? Candy's not in a worse position. She agreed to this 7 years ago. It's exactly what she had agreed to.
I have an answer
Where's
to
the
that.
foul in it?
Respondent went through the entire marriage in the knowledge that there was not a valid agreement. And she could very well have made decisions during that time that she would not have made if there had been a valid agreement. She repeatedly, as her affidavit says, she repeatedly told her husband that there was no agreement. He'd never given her a signed agreement, that there was no agreement. And he threw in her face, there's a prenup, but there wasn't one, and she knew it because she hadn't gotten it. And she could very well have made decisions, as I say, for example, she could have made a decision not to save money on her own during the marriage when money was available to her, that because she knew that there was no agreement, and so she'd have access to all of the funds of the joint marriage. So there are all kinds
There's a
of-
fundamental issue, I think, that is it may be a mistake, that is underlying, I think, both of your views on this, which is that I think you're both assuming that Mrs. Anderson couldn't have made on her own a great deal of money, much more than her husband, or that somebody in her position, because we're not talking about these parties in particular, during the marriage. And that if, as your adversary said, the agreement would not have been enforceable against him if he didn't sign it, in that circumstance, she's not getting anything like the benefit of her bargain, right? She could have made a tremendous amount of money, and he could say, oh, you know what, the prenup is not enforceable because I'm not signing it today.
That's exactly right.
And that's a problem.
Yeah, that is a problem. That's a problem for her, because if she knows that it's not, if she's operating throughout the marriage as if it's not in effect, it's totally up to him.
My point is, even if she's not operating that way, even if she just hits the lottery on her own nickel,
If it's totally up,
it's not a question of her reliance, I think, is it?
well, I think to some extent that it is, and I think that that's what the Fourth Department indicated in their decision. But I think that if she had been, if he could decide whether to...
Excuse me, let me ask this.
Sure.
Isn't your argument, aren't you asking us to say, judges, number one, was there a contract in the absence of the signature and acknowledgement, right?
Right, yes.
That's the first thing. And if there wasn't a contract, then what's the standard that we apply to determine if there may have been a contract, and that would be a reasonableness standard, a reasonable person standard, as we would with any contract, right?
Right.
So he signs it late, so he waits 7 years to sign it, or whatever the time period was. How long is too long, and is that reasonable? That's let me just finish.
I'm sorry.
That's the second part of it. Is that correct?
Well, I think that it's correct to a certain extent. Obviously, if a year goes by or a significant
Well,
period of...
let me answer this. If the reasonable standard is what you're asking us to apply, what you're really asking us to do is say, you want this to be a jury question. You want this to go to a trier of fact to determine whether or not there was a contract here when he signed it 7 years afterwards. Did that change the nature of the contract, or was there a contract to begin with?
What I'm saying is that that after a short period of time, her signature and acknowledgement have to be reaffirmed. If he's going to wait a year, 2 years, any significant period of time, then he's got to get her signature reaffirmed so that they're entering into the contract at the same time.
Thank you.
Thank you, counsel.
Thank you very much.
Counsel, I took the liberty of reserving 1 minute for rebuttal time for you, if you care to exercise.
Thank you, Ron. Council's aware of the concerns raised by the court, but again, these are like public policy concerns and rationales for why the existing rule should be perhaps amended. But the reality is that in private practice, these agreements are executed in counterparts on a regular basis. And now, without having a definitive rule, if we're going to have a rule that comes out that retroactively invalidates them, I think that creates an uncertainty in the law and a chaos. Because as I leave the courtroom today, I don't know what to advise clients in terms of how long between signatures or how long between a signature and an acknowledgement is valid or invalid. So that is all the more reason why such a issue should be resolved through the legislative process so that it gives notice to all the parties and all the litigants in New York State.
Thank you, sir.